a chartered engineer. He is an international faculty on maritime arbitration and international commercial arbitration. He is a member with London Maritime Arbitrators Association, International Council for Commercial Arbitration, MCCI Arbitration and Mediation Center, Mauritius, and many others. He writes passionately for international law journals. He is also an adjunct faculty with maritime and law universities in India, Asia, and Asia Pacific. We also have with us today Advocate Johnson Gomes, who is the director at Cochin Institute of International Arbitration, Advocate Safi Mohan sir, who is an assistant professor at Government Law College Tiruvananthapuram, and also our conveners, Advocate Nilima Nair and Advocate Sunita S. They are the ones who puts in all the hard work and dedication to make this happen, and hence it's a pleasure to extend my big welcome to you all. Lastly, and most importantly, I would like to welcome all the LGRF members and other participants. I hope that today's session inspires ideas and discussions. Thank you.
Thank you so much, Vamsi. Before we commence with our today's session, it would indeed be beneficial if we could have a brief review about our previous session. For that, I now invite an inquisitive and critical law student, Miss Amina. Miss Amina.
Thank you, Uttara. A very warm good evening to all. Myself, Amina SM, fourth year BA LLB student, a volunteer of LGRF Trivandrum chapter. So we are successfully here on our sixth session of arbitration, where Law and Justice Research Foundation, Trivandrum chapter, and Cochin Institute of International Arbitration constitutes. So basically, I am vested with the duty of giving review of our previous session happened on 20 November 2020 with the key speaker, Advocate Rajiv Shankar Dwivedi. Session was held with the topic Jurisdiction and Power of Arbitrators. Our speaker emphasized majorly on the Indian perspective of arbitration. He mentioned relevant sections of Arbitration and Conciliation Act 1996 that I'll be defining later. He started by defining the three sources. They are mainly agreement, law, personality of an arbitrator regarding with the power and jurisdiction of arbitrator. By agreement itself, the arbitration proceedings emerges. It's the basic of arbitration. An arbitrator works according with the agreement. Section 7 of Arbitration and Conciliation Act defines the arbitration agreement. It's an agreement between individual parties and their willingness to settle the disputes arises between them with the help of a private body, a third person, that is the arbitrator. Actually, he is the creation of an agreement. The power relies itself on the arbitration agreement. To make it more clear, Dwivedi sir mentioned section 10, where Act defines the number of arbitrators that we know, like arbitrators are chosen like odd number category. Then he mentioned section 11, which deals with the appointment of arbitrators. Parties are free to choose the numbers of arbitrators. Suppose if a case creates any difference in opinion, then the chairman could take a call. It goes with the ratio of 2:1, 3:4, like that. So the arbitral tribunal should follow these aspects. Otherwise, the arbitration cannot move smoothly. Acting as an arbitrator and advocate for our client is both important and have to deal it with very professionally. But in both cases, as an arbitrator and advocate, the power is not at all equal. In end of arbitration process, award is declared by the arbitrator. And we know the courts have powers because our constitution says so. Comparing Article 124 of our Constitution, there shall be a Supreme Court with a Chief Justice and judges not more than 7. And in Article 214 and 215, there have to be a High Court for each state and High Courts to be court of record, including the power to punish for contempt itself. So we understood that courts get power as Constitution says so. But in the arbitration, it is lot a different scenario. Like this is why we should know the genesis of both the powers. Similarly, in arbitration order, the final statement, that is the award of an arbitrator, is binding upon the parties. Why? Because the agreement says so. This is the significance of arbitration agreement. This is why arbitration agreement must be drafted carefully, because that there we as a party vest power to the arbitrator. The impact of vesting the power, here Dwivedi is discussed section 17 of that arbitral tribunal shall have the same power of making orders as the courts has the purpose of and in relation to any proceedings to it, and it's raised to the pedestal of being a court. So this is why it is not an ordinary exercise, it is not that simple. And it also mentions subject to any order passed in an appeal under section 37, any order issued under the particular tribunal section be deemed to be an order of the court all purposes and shall be enforced as the civil procedure. Section 17. What is Section 17? It is the interim measures ordered by arbitral tribunal. We can apply for appointing guardian for a minor, then unsound person, for appointing a receiver, or for an interim injunction, respect to with preservation, interim custody, etc. So here a person or a collection of person who are termed to be a tribunal turns to court. That means their word will be a word of as a word of court. So this is the first source of power and jurisdiction of arbitrator, which is the arbitration agreement. Now moving on to the second source, that is by law. Primarily, the Arbitration Act, which is our Arbitration and Conciliation Act 1996, defines some powers which are directly vested upon arbitrator. But the basic is the arbitration agreement. We all are aware about the Arbitration and Conciliation Act, the Arbitration and Conciliation framework in India, primarily based on the ancestral model law. Then, due to the lack of clarity with respect to arbitral procedures, the Arbitration and Conciliation Act 1996 was enacted. It did mention the mechanisms of arbitration. So, it basically ensures the arbitration proceeding are just, fair, effective. Then there are rules laid down for international as well as the domestic arbitration and conciliation. So here I want to give a simple explanation on the difference between what is conciliation and what is arbitration. So conciliation is where parties with assistance, okay, with assistance from a dispute resolution practitioner, that is our conciliator, discuss issues to reach an agreement. Second, so now in arbitration, where the parties to a dispute present arguments and evidence to a dispute resolution practitioner. Here dispute resolution practitioner is the arbitrator. He makes binding decisions. The third source is the by personality of arbitrator. Third power is based on the personality of the arbitrator. Here what is more relevant is that knowledge and experience of the arbitrator in the particular field. Particular field in the sense, mean the subject matter of the arbitration. Of course, as I quoted on the previous reviews, mostly parties chose arbitrators who have both experienced in both domestic and international scenarios, aware of both aspects. So actually it goes without saying that arbitrators must act with utmost integrity, must decide cases fairly, clearly, neutrally, without being biased to one party. Value trust and goodwill of parties. Then he did mention section 18 of Arbitration and Conciliation Act. It defines equal treatment of parties. The parties shall be treated with equality, and each party shall given full opportunity to present his own case. An arbitrator must have 3I, which is integrity, intelligence, and image. Now, if you look at the duty of arbitrator, it goes as per section 12, 13, 14, where it prescribes to display the impartial neutrality of arbitrator, like making a declaration that the arbitrator is not connected with either of the party, where we are aware of three lists, that is red list, orange list, and green list. If the arbitrator falls within the relationship mentioned the red list, that will probably include most close relationship, then arbitrator cannot arbitrate. If he falls under the relation mentioned in the orange list, then with the consent of parties he may arbitrate. And if the arbitrator falls in relationship other than red or orange, that is the list, green list, then he just have to make the declaration. And if there is no objection, then he can arbitrate the particular case. This list was actually adopted from IBA guidelines. Independence and impartiality of arbitrators are the hallmark of arbitration. This was actually aimed to bolster not only for maintaining neutrality but to the whole perception of being neutral as an arbitrator. All these three lists, they have been inculcated in the fifth and seventh schedule of the Arbitration Act. If we go through the above mentioned schedule, that is the fifth and seventh schedule, it has given great details that the relationship of arbitrator with the party, with the dispute, with the counsel, everything. Actually, it is a very interesting topic. So, as per the green list, orange list, and the waivable and non-waivable red list, the grounds are stated in fifth schedule as guide to determine whether the circumstances exist which would raise the justifiable doubts. Justifiable doubts on the independence of or impartiality of an arbitrator. On the other hand, the grounds specified in the seventh schedule render a person ineligible to be a potential arbitrator. Here he mentioned 12 clause 5, it says, by notwithstanding any prior agreement to the contrary, any person who is in relationship with the parties of counsel or the subject matter of the dispute or falls under any category specified in the seventh schedule is ineligible to be appointed as an arbitrator. So seventh schedule, the red list as prescribed under ancestral model law, but there is a proviso on it. It is provided only in India. Like actually, whatever has done by the red list, notwithstanding that the person who is an arbitrator was earlier the chairman in the same very organization, but if other side give consent or if other side have no obligations, he can act as an arbitrator. Suppose if a party not in a position who has been coerced or pressurized, so he can be precised into, even with affidavit undertaking provision under section 12 clause 5. Any person can act as judge in his own case. That also determines the power of arbitration. This is why proper implementation of section 12, 13, 14 is quite important. Actually, arbitrator is given such important positions that any challenge to the arbitrator or about his competence given to itself only. Suppose if someone wants to challenge or question the arbitrator, if we don't have to go for seeking help from other authority. There is a principle of competence. It say that the arbitrator is competent to decide upon a challenge about the ability of doing his particular arbitration or about the jurisdiction. It must be raised in front of the same arbitrator. This falls under section 13. If the party agrees the procedure, then everything supersides by that. If a party challenges the arbitrator, they must be given a written statement mentioning the reasons for the challenge to the arbitral tribunal itself. So, so the basic thing is wherever the two parties meet and agree upon whatever point they agree, that will override every other provision. Normally challenges like not having proper agreement, parties are not correctly represented, dispute arised is not sorted in arbitration, arbitrators not at all qualified, etc. These are the basic challenges raised. Where if arbitral award made under subsection 4, the party challenging arbitrator may lay an application for set aside the arbitral award in accordance with section 34. He cannot challenge immediately. He have to wait till the award is declared. Okay, so he gets additional one ground. The challenge rely by section 34 only. So it deals with the process and grounds of challenges of arbitration. We know the court decides case on the basis of fact, equity, sense of justice, fairness, reasonableness, etc. But these concepts are not available for an arbitrator until it is vested upon him by the agreement. If we check section 28 clause 2, there is two Latin terms given, ex equato bono and amiable composition. According to that, what is equitable good? And similarly, in amiable composition clause, it is conventional renunciation to the benefit of rule of law. The party using to request strict application and to moderate this contractual provision, provided to equity or common interest of party requires it. It simply means that the arbitrator can have the power to decide the dispute on the basis of equity. He can mold the consequences of agreement. He has to have specific authorization provided by the party. If there is none, then he cannot do it. He has to go by what as the prescribed in the agreement, even if it has a bit unequitable or a bit absurd. So an arbitrator is not same as judge, that we know. This mentions the control of the power on arbitrator by the arbitration agreement. Wherever parties lack power, arbitrator could have extra power. So now we can move on the section 18, the last section, which the way these are explained that the soul of the entire arbitration act, we should equally treat our parties. When we comes to section 19, act says determination of rules of procedure. That means arbitral tribunal shall not be bound by the Code of Civil Procedure Code and the Indian Evidence Act. Subject to this, parties are free to agree on the procedure to be followed by the arbitral tribunal in conduction of arbitration. So summing all these things, it means that if parties lack to produce or mention the procedure that if the parties lack to produce or mention the procedure, then tribunal takes the part. So further says, if no procedure is prescribed by party, then the tribunal itself forms its own procedure. So yes, it is a great power. If as a party we don't want our arbitrator to take it more grandly, then we must mention our part. That means in the agreement. So wherever the parties have not provided it in agreement, the procedure, then the freedom has given to the arbitrator itself to decide what he wants to opt or like that. This is why section 18 is special for parties. That is the failure of appointment procedure. So the whole definition of arbitration is the point which emanates from the power and jurisdiction of an arbitrator, that the previous session's topic. It was okay, so this is it. It was a really informative session, and yeah, I show my gratitude to Advocate Dwivedi sir and Advocate Johnson Gomez sir and Safi sir. Then I wish everyone have a fruitful session ahead with our eminent speaker, who is a chartered engineer, Shri Madhavendra Singh. Thank you so much.
Thank you so much, Amina. I'm deeply honored and delighted to invite our most respected speaker of the day, Shri Madhavendra Singh, an international arbitrator, Navy commander appointed with the Ministry of External Affairs, fellow of Chartered Institute of Arbitrators, and many more. I, with the deepest respect, welcome you to our today's session, sir. Along with him, I would like to invite respected Sri Johnson Gomez, Director, Cochin Institute of International Arbitration, a very familiar face to all of us here by his very truly advantageous and enlightening influence in our previous sessions. I welcome you, sir. And we also have with us today Nidhi Sachdev, Registrar General, Mumbai Center for International Arbitration. Thank you, ma'am, for gracing us with your presence today. I invite both our speakers to move on with the sessions.
So thank you, Uttara. Thank you, Amina, for the presentation. It was in fact a good briefing about the last session. Today we have Mr. Madhavendra Singh. We were awaiting to hear him. So he will be talking on the topic role of courts in arbitration. And he being an expert in maritime law, we wish to maritime arbitrations. We wish to hear from him his experiences as a maritime arbitrator and the scope for how to develop a career in maritime arbitration. I think that that will be an interesting area where our students will be very keen to hear. That will be a very short, brief session after the main session that relating to role of courts. And maybe if you have any questions relating to these two sessions, you can ask him. Uttara, even if it moves beyond the time, please bear with him. Okay, thank you.
Okay, sir.
Welcome you, sir, to speak on the topic role of audit. And thank you very much, Nidhi, to be part of this session. Thank you.
So, good afternoon, everyone, and thank you, Mr. Gomez. Thank you so much, one, for organizing these kind of training events, and also for inviting me to, speak on the topic of role of courts in arbitration. I'm really also delighted to see distinguished guests among us. Ms. Sachdeva is here, who is the Secretary General of the MCIA, the Mumbai Center for International Arbitration. A very warm welcome to all the distinguished guests, and thank you for all the organizers and the participants. And I'm very impressed with the introduction that Amina has given, actually. She has briefly almost covered all the aspects of international commercial arbitration. And I think, in a sense, that is what it matters. And I am very also glad to see that there is a lot of awareness which is coming about in the practitioners of not only law, but also other fields of trade and business. So today, I'm going to speak with all of us on the role of courts in international arbitration. And may I just take one moment to request all the participants to just cross-check if your audio and video is off, so that we can optimize the bandwidth and people don't find a problem in receiving. And also there is no crosstalk when we speak. Thank you. Thank you very much. Also, there are no housekeeping announcements. I'm sure by now we are all very conversant with the usage of these kind of online platforms. Once again, thank you very much. And as we talk about the international arbitration, all these conventions like the New York Convention, the Geneva Convention, and the Ancestral Model Law, they all talk about a concept or a policy of judicial non-intervention in international arbitrations. That basically says that courts should have a minimum intervention as far as the international commercial arbitration is concerned. And they also, promulgate a fine balance between what is called as the intervention versus the assistance. I mean, whether the courts should be there to assist the arbitration, or should there be some provisions for intervention as well. So, as we all know, arbitration is an alternate dispute resolution process, but it differs from other ADR methods of conciliation and mediation in the way that it is, at the end of the day, an adjudication of dispute. And like Amina also talked about amiable compositor. So that is a concept which is not known in India as of now, because we have adopted the Ancestral Model Law. So the countries that are signatories to the model law are basically known as the model law countries. India is one of the model law countries, and in the model law countries, arbitrators are not given that kind of a flexibility to act as amiable compositors, where they can advise the parties to settle their disputes. Arbitrators are adjudicating the dispute; they are not looking at the settlements. And their arbitrators must also keep in mind that they should not at any point in time make an effort to request the parties to settle the disputes. Their role is to adjudicate on the merits of the case and governed by the procedural laws of the seat of the arbitration. So that also basically I would want to touch upon the concept of seat versus venue before we move on. Our act, the Arbitration and the Conciliation Act 96, also talks about the place of arbitration. Interchangeably, people have confused the concepts of place, venue, and seat. But if an arbitration agreement explicitly talks about a selection of seat, the seat of arbitration is basically which basically means that the procedural law, the arbitration act of that particular state or that country would be applicable for the particular arbitration. And in the absence of an explicit choice by the parties in their arbitration agreement about a seat, and if they have mentioned a place, so in a loose sense, basically the arbitrator or the tribunal would basically come to a conclusion after having applied the facts of the matter and the closest connection approach. But where it talks about place, the place would probably, the seat of arbitration. So there's some concept, basically arbitration resides, the foundation of arbitration is laid on a principle of party autonomy. There's a French adage called as l'autonomie de la volonté, which fundamentally means it is the will of the parties that will govern the arbitration. And we must all remember that an arbitration and an arbitral tribunal or an arbitrator, they are the subjects of the arbitration agreement. As far as the courts are also concerned, when the parties approach courts, and the courts have the powers to refer a dispute to arbitration under Section 8, the courts are only required to prima facie see that there is a valid arbitration agreement that exists, and no further. So in my presentation, I will be taking you through all this. So national courts, whenever I'm talked about or I'm asked about the role of national courts, I'm actually reminded, very anecdotically speaking, of this, famous statement in the movie called Avengers. I'm sure most of us have seen this movie called Avengers, where there is this mysterious benefactor called Thanos. And the statement that he makes is that I'm inevitable. So the underlying fact is, in arbitrations, courts are inevitable. And for good many reasons, which we will cover. So parties have been given, the tribunal, the arbitrators have been given certain powers and the flexibility at par with what the courts have, but they are not ad libitum. So what I'm trying to say is they come with certain kind of limitations. And as regards to why did we move on to arbitration is because the courts, these national courts are bound by the four boundaries that are within of the coded laws. Like, for example, Amina also mentioned about Section 19, which says that it shall not be binding. The Evidence Act and the Civil Procedure Code shall not be binding on the arbitral tribunals to be basically applicable. So where does, and why is that so? Let us understand why is that so. I mean, why is it not mandatory for the tribunal to look into the Evidence Act while taking evidence? That's because even international arbitrators will be there who are presiding over your arbitrations. Now you can't expect international arbitrators to understand the Evidence Act of India, and vice versa. Any lawyer from India or any arbitrator or a judge from India who has learned the Indian Evidence Act, would you expect him to understand the Evidence Act of Singapore if arbitration is seated in Singapore? So these are the things. That is why the IVA guidelines on taking of evidence, the IVA guidelines on conflict of interest for the independence and impartiality of the arbitrators, these are called as the soft laws. So arbitrators find it very convenient to at least understand these soft laws so that the conduct of the arbitration proceedings goes smoothly. And they're basically conversant with the procedures of conduct of arbitration. So I have a presentation for you, and I am also, I also understand does not make it mandatory for all of us to have this act. This is the Arbitration and Conciliation Act 96. People who have can refer to it, but I have in my presentation slides verbatim put the clauses there, the sections, so that you can read it and we can discuss it there. And I would not like to hurry up. We will try and cover as much as we can so that at least what we learned today, that we learn properly. I would not hurry up to basically finish the whole thing. Whatever we do, but let us do it in a proper manner. And if anybody has any questions, they can write and probably Amina or somebody can take those questions towards the end of the presentation. And just allow me 30 seconds to start my presentation. Someone will have to, Mr. Gomez, you will tell me if you can see my presentation and you can hear me also, right?
Yeah, I can now see your screen.
What about the presentation?
Not yet.
One second. Just bear with me. Let me just.
Yeah,
Okay,
we can do that.
You can see my presentation now?
Yeah.
Okay, perfect. Okay. So we are going to talk about the role of courts in arbitration today. And as we move ahead, I would want us to basically understand the kind of amendments and with respect to the acceptability. I mean, the amendments that have occurred in 2015 vis-a-vis the amendments in 2019 and what went about. So we know the relevance of the enforcement of arbitral awards as far as the jurisdiction in India is concerned. So in 2018, basically, in 2015 amendments, what had happened was, see, before the commencement of the Arbitration Act of 2015, the amendment, Section 36 of the Arbitration and the Conciliation Act provided that an arbitral award would become enforceable as a decree only either a petition under Section 34 of the Act challenging an award has been dismissed, or the time limit provided for the challenge of an award under Section 34 has expired. So in other words, during the pendency of a petition under Section 34, an award could not be enforced. So this basically was a clause on the rights of a bona fide award holder, which prevented him from reaping the fruits of having a successful arbitral award in his favor. And this was termed as an automatic stay. So before a 2015 amendment, there was an automatic stay on the arbitral awards, because if there was a challenge under 34 or 1 month period of basically for the challenge, which is provided, it's not yet over, parties could not go to courts to enforce their awards. So this was set correct with the 2015 amendment. The amendment introduced large-scale radical changes to the Act, which were aimed at reducing the delay during the proceedings and enforcement of the resultant award. Significantly, the 2015 amendment substituted the existing Section 36 of the Arbitration Act to provide that merely availing the remedy under Section 34 of the Act does not render an award unenforceable unless a specific stay has been granted. So basically, what we should understand is after 2015 amendment, the parties could not just utilize the remedy of 34 and sit on their awards, saying that because the courts are adjudicating my challenge application, so the award is still not enforceable. And pertinently, Section 26 of the 15 amendment expressly provided that the 2015 would apply to arbitral proceedings which commenced on or after the date of commencement of the 2015 amendment, that is from 23rd of October 2015. So when 2015 amendments basically said that the awards could be enforced for all the arbitrations which are starting after this cutoff date, as also the arbitral awards that are under the challenge proceedings before this cutoff date. So basically in both the matters. So now in 2019, that introduced some amendments to the Act which significantly altered the complete regime of arbitration in India. And one of the major amendments that was introduced was the Section 87. If we know of this, this was basically, I think the Supreme Court has basically, set aside this particular section, and they had upheld the previous judgment in the BCCI case, and basically resorted to the promulgation of the features that are available with the 2015 amendment. So Section 87 provided that the 2015 amendment would be applicable only to the proceedings which commenced on or after the cutoff date, and to such court proceedings which emanate from such arbitral proceedings. And Section 15 of the amendment also deleted the Section 26, which basically provided that the arbitrations which are also in the challenge application would also, the awards could also be enforced. The 2019 amendment then was challenged in the Supreme Court on the aspects of introduction of Section 87 and deletion of Section 26 of the 15 amendment. The Supreme Court, in a judgment passed on 27 November 2019, in the Hindustan Construction Company Limited, the CCL case, struck down the insertion of 87 on the provision of basically calling it a manifest arbitrariness, and basically they struck down Section 26 of the new amended Act. So the Supreme Court in BCCI versus Cochin cricket clarified that the new Section 36 introduced by way of the 15th Amendment would apply even to awards in cases where a petition under Section 34 of the Arbitration Act has already been filed as on or before the cutoff date, thereby doing away with grant of an automatic stay due to the mere pendency of a petition under Section 34 of the Arbitration Act as on the cutoff date. So this view taken by the Supreme Court has been seen to be in line with the object of the 2015 amendment, that is reducing the delay during arbitration proceedings and enforcement of the resultant arbitration awards. However, the introduction of Section 87 by way of 2019 amendment nullified the effect of the said judgment. However, in the judgment, the Supreme Court has held that introduction of Section 87, which has the effect of reinstating the concept of automatic stay on the operation of arbitral awards if the petition was being heard under Section 34, and basically it was objected in the Supreme Court. Therefore, Section 15 of the 19th Amendment removed the basis of the judgment of the BCCI case, and from the very day it became into force. Since this is the provision that has been construed in BCCI, the fundamental prop said that judgment has been removed, but retrospectively omitting Section 26 of the 15th Amendment altogether from the very day when it came into force. So all in all, by striking Section 87 of the Act, the judgment brings the Honorable Supreme Court of India's decision in BCCI back into operation, which held that Section 36 of the Arbitration Act will be retrospectively applied. So what I'm trying to basically bring to your notice here is that after 2015 amendment, let's say many of the public sector undertakings, public sector enterprises, which had multiple awards against them, and they had a lot of dues to be paid out in thousands of crores. So this was a kind of a thing in 2019 amendment, which was brought in by way of a legislation, saying that there would be an automatic stay if you go into a Section 34, which allowed these big enterprises to not pay their debts. So because if you went into a 34 application, you would not have to, award would not be enforced, and you can continue to, be adjudicated in the courts for, keep perishing in the courts for a long time. But thankfully, this award has been shot down by the Supreme Court, and again, the 2015 amendment is applicable. But there are certain case laws that we might like to refer to exact interpretation of these clauses. As far as the Act is concerned, we should understand the definition of the courts. What is the understanding of courts for the purpose of arbitration? And this is as per the 1999 Act. I will just read out for the benefit of the people who have not gone through this clause. So this is section 2(1)(e). The court means that in the case of an arbitration, other than international commercial arbitration, that is, we're talking about the domestic arbitration, the principal civil court of original jurisdiction in a district and includes the High Court and exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration if the same had been the subject matter of a suit, but does not include any civil court of a grade inferior to such principal civil courts or any court of small causes. So this is divided into clause 1 and 2. 1 basically is applicable for the domestic arbitration, and the clause 2 is applicable for the international commercial arbitration. In case of international commercial arbitration, the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration if the same had been the subject matter of a suit, and in other cases, a High Court having jurisdiction to hear appeals from decrees of courts subordinate to that High Court. So in case of international commercial arbitration, only High Courts have the jurisdiction. So we will see also as regards the jurisdiction of these courts, which is codified in section 42 of the Act, and says, notwithstanding anything contained elsewhere in this part. So this wording is important to understand, which makes specifically section 9 interim measures where explicitly if seat is not chosen. So this particular clause will come in handy there. So notwithstanding anything contained elsewhere in this part or in any other law for the time being in force, where with respect to an arbitration agreement, any application under this part has been made in a court, that court alone shall have jurisdiction over the arbitral proceedings, and all subsequent applications arising out of that agreement and the arbitral proceedings shall be made in that court and in no other court. So court therefore will be the one in which civil suit would lie, and if you see the CPC section 20, will also determine the jurisdictional court. Basically, if a parties are wanting to understand that which court they should approach if a dispute arises, they can refer to this particular clause, the court that has jurisdiction in that case. So in the event of more than one court having jurisdiction, the first court will become the exclusive court of jurisdiction. Wherever the parties have first gone, if you have let's say the cause of action has occurred in two places, or the parties are from two places in India, and the seat is also decided, let's say, as one of the states, but parties have gone to the case, courts in both the places, then which court will have a jurisdiction? If both are valid, then whichever party went to particular court first would have the jurisdiction in that matter. So as regards which court will have the exclusive jurisdiction, again, my comments on section 42, we are referring the case law of BGS SGS Soma versus NHPC of 2020, the Supreme Court judgment. Section 42 aims at avoiding conflicts in jurisdiction by placing supervision of all arbitral proceedings in one court exclusively. It is important that the arbitral proceedings and all matters related to that particular dispute are heard in the same court, and the different courts do not take jurisdiction in that particular dispute. Usually the place or the venue of arbitration does not itself become the seat of arbitration. But when there is an express designation of a venue and no designation of any alternative place as the seat, the stated venue is actually the juridical seat of the arbitral proceedings. This I spoke about in my introductory also, that the difference in the seat and venue, but in case there is no explicit choice of seat, then venue would probably become the juridical seat, depending on how the arbitral tribunal looks into the facts of the matter. Thus, seat can be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. So when the arbitration starts and there is no seat that has been explicitly agreed upon by the parties, they can do so during the proceedings of the arbitration as the arbitration commences. So the courts that will have jurisdiction is the court at the place where the seat is determined will have exclusive jurisdiction. So if, let's say, there are two international parties and the seat is India, the Arbitration and the Conciliation Act of India would be applicable. And the courts, for all practical matters, parties will have to go to the courts in India only because it is arbitration seated in India. The courts of India will have jurisdiction. Similarly, if a seat was Singapore, the courts of Singapore would become relevant, and for every assistance from the courts, the arbitrator or the tribunal would have to basically go to the courts of Singapore. The fact that a part of the cause of action may have arisen in another place would not be relevant. This basically sees that if you have chosen a seat, doesn't matter where the cause of action occurred. If the seat is Singapore, cause of action could have occurred in London. Does not mean that you will have to go to the courts in London. If there is a seat which is exclusively agreed upon, only the courts of that particular seat jurisdiction will have jurisdiction. However, a Section 9 application, this is important. Section 9 application may be preferred before a court at a place where part of the cause of action arises and where parties have not agreed on the seat of arbitration, and before such seat is determined by the arbitral tribunal under Section 20 of 2, subsection 2. So this basically says that if there is a dispute that has gone before the court and there is a valid arbitration agreement, but the parties have not chosen an explicit seat there, but they are seeking, a party is seeking an interim injunction or an application, applies for an application for interim measure, the court can take jurisdiction because there is no seat decided and basically give an interim measure of protection under which is basically permitted if you see Section 20 subsection 2. And since when I mentioned earlier to you of Section 42, the wordings notwithstanding anything contained elsewhere in this part makes it valid. In the absence of an explicit choice of seat, a court can take an application section under Section 9 for interim measures and take jurisdiction because Act allows it and because it says that there is not withstanding anything contained elsewhere in this part. So that will be in compliance with the Act. So all in all, in comprehensive manner, let me give you a slide or two as to what are the scope of interventions by the court. There are few sections here, which I think if we learn through, and it can be on our tips of our finger once we get through all of them. First is the Section 5. This is the act that states what is the extent of judicial intervention. Section 11 is one of the most important sections of the act, which talks about appointment of arbitrator. And if you look at the act also, you'll realize that Section 11 is the largest of all the sections in the act itself. Section 8 is the power of the courts to refer parties to arbitration where there is an arbitration agreement. So in this case, the courts would prima facie look at the validity of an arbitration agreement. Section 13 is the challenge procedure, challenge to an arbitrator. If parties need to challenge the arbitrator, the procedure for undertaking that challenge is under Section 13. Section 14 is for the failure or impossibility to act on part of an arbitrator. Section 15 is in case of the termination of mandate or substitution of arbitration is required, then what is the procedure? Whether the way the arbitrator was appointed would still apply, or whether they have to go to the court, or the parties can nominate their arbitrators like they did earlier. So the Section 15 would basically list out the procedure for that. Section 9 is the interim measures by the court, and 17 is the interim measure by the arbitrator. 17 subsection 2, these are the orders that are subject to appeal under Section 37 that talks about the orders. Section 27 is the assistance that can be taken from courts as regards taking of evidence is concerned in an arbitration. And 29 alpha is with respect to the time limits for an award and how much time should the award be published, and the extensions with the agreement of the parties which courts can basically give. Section 31 alpha is the regime of costs. What are the costs applicable and what are the privileges or the powers that the courts and can basically give to the tribunal as well. Section 34 has been conceived from the New York Convention, and this is for application for setting aside of an award. Section 36 is towards enforcement of the arbitral award. Section 37 is subsection 1 is basically appeals from, talks about the appealable orders, and only the following orders can be appealed in the appellate courts, which are like, one is refusing to refer parties to arbitration under section 8. If a court refuses to refer the parties to arbitration where there is a valid arbitration agreement, this order of the court can be appealed in the appellate courts. The granting, refusing of relief under section 9, that is, if a court refuses to give a relief, the interim measure under section 9, that order can also be appealed in an appellate court. And setting aside and refusing to set aside award under section 34, if your challenge proceedings under section 34 are also basically refused, then you can appeal that particular order in a court of appeal. Section 37, subsection 2, this is appeal from orders of the tribunal. There is accepting plea under section 16, subsection 2 and 16, subsection 3. And also for granting and refusing interim measures under section 17, just like as in the case of courts. Subsection 3 is that no second appeal from an order in appeal under this section. So once you have appealed against a particular order, there will not be a second appeal in that particular case. And all the appellate court is the Supreme Court in matters of such appeals. Section 39 is there, which talks about a lien on the arbitral awards and deposits that have to be made by the parties as regards to the costs. Sometimes the lien on an award may be necessary where the arbitrator feels that the parties are not paying the dues, so he can keep a lien until he is given the award. And Section 43 talks about the limitations, which basically validates or says that the Limitation Act would be applicable as is in the case of the Limitation Act. So now I would briefly touch upon these sections. We'll talk about some of the critical and the important ones. The Section 5 talks about the extent of judicial intervention. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. Part 1 provides for judicial intervention by the court in the proceedings under Section 8, 9, 11, 14, 15, 27, 29A, 34, 36, and 37. So there are 4 kind of categories. If we talk about the intervention of courts, we can broadly classify them into 4 categories. Let's say one is facilitation. So under Section 8, that is powers of the court to refer the matter to arbitration. Section 11 is with respect to the appointment of arbitrators by the court. 27 is with respect to taking of evidence. And 39 is the appealable orders. So this is where the court is basically facilitating the arbitration. And then another category is interim or the conservancy, we call it. These are for Section 9 and 17, which are interim measures by the court and the tribunal. Then there's a supervisory function that courts would also perform, like as in case of Section 13, which is the challenge to an arbitrator. And the Section 14 is the failure of an arbitrator to act as an arbitrator. And 15 is the termination of an arbitrator or basically is the replacement or substitution by the courts. And 29A is the time limit for giving out an award. And 31A is talks about the regime of costs. These are the supervisory functions that the courts perform. And then there are certain adjudicatory functions also, which are only residing with the courts, which is section 34, that is the challenge to an arbitral award for setting aside application. 36 is the enforcement of an arbitral award. 37 is the appealable orders, appeals that are arising from these orders by the courts or the tribunal. And 43, which talks about the limitations, basically the applicability of the Evidence Act of 1963. So let's talk about the section 8, which is the power of the courts to refer parties to arbitration where there is an arbitration agreement. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies, not later than the date of submitting his first statement on the substance of the dispute, then, notwithstanding any judgment, decree, or order of the Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. So there would be occasions sometimes where parties explicitly also choose the law governing the arbitration agreement itself. That makes the case easy for the courts and the tribunals to basically look at the validity of the arbitration agreement. So we talk about the conflict of laws that would be applicable when there is no explicit choice of laws governing the arbitration agreement itself. The application referred to in subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof. So the parties going to the court, basically applying to for the court to refer the dispute to arbitration will have to give the court the original copy of the agreement itself, which contains the arbitration agreement, and it has to be a true copy or the original copy. So provided that where the original arbitration agreement, let's see a case scenario where the arbitration agreement or a certified copy is not available, with the party applying for reference to arbitration, and the said agreement or the certified copy is retained by the other party to that agreement, then the party so applying shall file such application along with a copy of the arbitration agreement and a petition praying the court to call upon the other party to produce the original arbitration agreement or its duly certified copy before that court. So in case the party applying for such an application to refer the matter to arbitration does not have the original copy of the arbitration agreement, it can request the court to basically ask the other party or send orders to the other party to basically present before the court the original copy of the arbitration agreement. Notwithstanding that an application has been made under subsection 1 and that the issue is pending before the judicial authority, an arbitration may be commenced or continued and an arbitral award can be made. This is very important that during the pendency of this particular application under section 8, the arbitration can still continue and award can still be given out. After the 2015 amendment under section 8, to judicial authorities, the scope is confined to examining only the existence of a valid arbitration agreement. Like I mentioned to you, the courts, what shall the courts do is only look at the prima facie existence of a valid arbitration agreement. However, the respondent has to make the defendant has to make an application under section 8 before the judicial authority before the date of submitting his first statement on the substance of the dispute. He has to make it that application before he submits the statement on the substance of the dispute. If such application is not made, a suit has to be proceeded with. Then he cannot go into arbitration. Reference of the disputes between the parties to the arbitration agreement cannot be refused on mere allegation of fraud against one party by another party made in the plaint. So, let's say a party has gone to the court for the reference to arbitration, but that other party says that this contract was, got into by way of fraud, or there is an element of fraud involved. Just because there is an allegation from the other party does not stop the courts from referring such a matter to arbitration. But in the case law of Ayasami, we see that if the allegations of fraud are very serious, which make a virtual case of a criminal offense, or allegations of fraud are very complicated, and it cannot be decided by an arbitrator, only such allegations of fraud can be decided by the civil court and not by the arbitral tribunal. In case courts find that an evidence which is in the favor of fraud, which basically brings out a complicated fraud or something which cannot be decided by a tribunal, then the courts will take jurisdiction, and it will be done by way of a suit. So this is Section 11 is one of the important sections of the Act and the powers of the court. This is with respect to the appointment of arbitrators. A person of any nationality may be an arbitrator unless otherwise agreed by the parties. That also makes me speak about Schedule 8, which was brought about in the amendments of 2019, which has yet not been notified, so it will not be wise for me to talk about it, but which came about certain qualifications that the arbitrators must have to sit as an arbitrator. But there have been a lot of comments and views from the stakeholders. So that is why the government has not yet notified that Schedule 8. But the Act itself allows any person, international person, to sit as an arbitrator to adjudicate any dispute in India as well. Subject to subsection 6, the parties are free to agree on a procedure for appointing the arbitrator or arbitrators. As far as the number of arbitrators is odd, which is governed by the Act, the parties can choose a method of appointment. They can also choose qualifications and number of arbitrators. Failing any agreement by the parties referred to in subsection 2 in an arbitration with 3 arbitrators. So this is the method of appointment which Act also codifies, that in case the parties have chosen for 3 arbitrators, the 2 arbitrators would be party nominated arbitrators, and the 2 arbitrators so selected or so nominated by the parties would then come to a common consensus on a presiding arbitrator. The presiding arbitrator is called by different names. He can be called as the chairman of the tribunal. He can be called as the presiding arbitrator. He sometimes in certain jurisdictions called as the referee. So here, I would also like to mention that, like what Mr. Gomez was talking about, maritime arbitration, there are certain sector-specific arbitrations where even 2 arbitrators are allowed to adjudicate certain matters, like in the case of specifically in the shipping disputes with the matters under the rules of London Maritime Arbitrators Association. The 2 arbitrators is valid. The 2
We can't hear you, sir.
Yes. No, you are on mute. No, I can say that you're still on mute. You may want to just switch it off and switch it on back again.
Sir, I think it would be better if you just leave from the meeting and then rejoin.
No, that's fine. I'm okay. I
We
think
can hear
Now
you
it's
now.
okay, sir.
We can hear you now.
now you can hear me, right? And you can see my presentation.
Yes.
Okay. No, I'm sorry. I think my AirPods just, died down. The batteries died, so I got off. Okay. So the Supreme Court and the High Court will have the powers to designate arbitral institutions. So sometime back with the 2019 amendments, we were also talking about something called as the Arbitration Council of India, which was to basically decide on the qualifications of not only the arbitrators but also grading of the arbitral institutions. But very significantly, they have brought in this arbitral institutions for appointment of arbitrators, and the Act allows for it. And what they went about saying is that every high court should have some graded arbitral institutions associated with them, so that they can ask or order these institutions to make the appointment of arbitrators, even if the parties came to the courts for such an appointment. Provided that in respect of those high court jurisdictions where no graded arbitral institutions are available, then the Chief Justice of the concerned high court may maintain a panel of arbitrators for discharging the functions and duties of arbitral institutions. And any reference to the arbitrator shall be deemed to be an arbitral institution for the purposes of this section. And the arbitrator appointed by a party shall be entitled to such fee at the rate as specified in the fourth schedule. So in the 2019 amendments, the state has come up with the fourth schedule, which codifies how the arbitrators have to be paid. But in case parties have chosen to go by the rules of a particular institution or arbitral institutions, then the rules of that institution would be applicable. The rules in case of how the payment has to be made and what is the schedule of fees for the arbitrators of particular institution would be applicable and not the fourth schedule. If the appointment procedure in subsection 3 applies and a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so from the other party, or the two appointed arbitrators fail to agree on the third arbitrator within 30 days from the date of their appointment, the appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration or high courts for domestic arbitrations, as the case may be. So 30 days is given for the parties to nominate their arbitrators. If they don't do so, then the courts can take cognizance of the fact and they can appoint. And also similarly for the arbitration institutions, I would say. Mr. Gomez, we have time, right? Or I'm just running out of time now.
Yeah, we have 20 minutes.
Okay, so I'll come to the comments, my comments that I have to make on appointment. Okay, I'll leave some time for the Q&A also. Let me just take 10 more minutes and just cover these few sections. So as far as the section 11 is concerned, after the amendment of 2015, the court has to only see whether the arbitration agreement exists and nothing more. The powers of the courts are limited, notwithstanding any order or decree. We have seen this particular thing. So in the case of Mayawati Trading versus Pradyut Dev Varman, this is a judgment of 2019 by the Supreme Court. So it talks about an omission of section 11 in the 2019 amendment. It says the omission is because the appointment of arbitrators is to be done institutionally, in which case the Supreme Court or the High Court under the old statutory regime are no longer required to appoint arbitrators and consequently to determine whether an arbitration agreement exists. Thus, the law laid down by, in the case of Duro Felguera, will continue to operate, and thus court cannot now go into whether accord and satisfaction has taken place between the parties. Courts will only look at prima facie availability of valid arbitration agreement. So let's talk about the interim measures by the court. Before and during arbitration proceedings, so when can a party go to the courts for seeking interim arbitration, interim measures during an arbitration is before and during the arbitration proceedings itself, anytime after making an award, but before it is enforced, they can still go for interim measure. And what kind of measures can be given? The measures include appointment of guardian or a minor, interim measures of protection like preservation of custody or sale of goods, subject matter in arbitration, securing amount in dispute, detention, preservation or inspection of any property or thing which is subject matter of the dispute in arbitration, and also authorizing person to enter the property, to take samples, observations for obtaining full information, or in case for an evidence and things like that. And then interim injunction, appointment of a receiver, court receivers. Only the courts can appoint court receivers. The tribunals can only appoint private receivers. And such other measures of protection as may appear just and convenient. If interim order is before the proceedings, the arbitral proceedings must commence within 90 days or extended time by the court. So after the interim measure has been given by the court, the arbitration must commence within the 90 days. Unless courts find remedy under Section 17 for existing circumstances may not be efficacious. They have to basically see that the validity of the agreement, and that's why they can refer the matter to arbitration, or they can ask, the courts can also, if the parties have gone to courts for seeking interim measures, the court can order an arbitrator basically, or refer the matter to an arbitrator or the tribunal to basically adjudicate over application of Section 17 and give an interim measure. So in the case of SBP and Patel Engineering, if dispute of jurisdiction is raised at Section 9 stage, then the court has to necessarily decide whether it has jurisdiction, whether there is an arbitration agreement which is valid, and whether the dispute sought to be raised is covered by that agreement. It is completely subject of the arbitration agreement between the parties. After the 2015 amendment, if an order under Section 9 is passed, the arbitral proceedings shall be commenced within a period of 90 days from such date. That we've already seen. So a party who has no intention to ultimately refer the dispute to arbitration and seek final relief cannot be permitted to seek interim relief. This comes from the case law of Ashok Traders. And the issue of whether reliefs under Section 9 can be granted when the agreement containing the arbitration clause is not or insufficiently stamped is also pending before the Supreme Court. So in case the contract containing the arbitration agreement or the arbitration agreement as a separate contract has not been stamped, so that's also something which is still to be decided, has different take in the different jurisdictions. Non-parties to the arbitration agreement can also be implicated in this Section 9 application if they are likely to be affected by the reliefs claimed. You can just refer to the case laws that I mentioned. I need not speak them out for you. Cannot ask stay of arbitral proceedings as an interim measure. The parties cannot ask for a stay of the arbitral proceedings itself as an interim measure. The principles of CPC and Specific Relief Act furnish a guide to the court for grant of injunctions. Court will basically refer to the CPC and the Specific Relief Act. And similarly, for attachment of property or securing the amount, also we can say the rules 5 and 7 of the CPC will also apply. Section 17 is the interim measures by an arbitrator or the tribunal. So after the 2015 amendment, arbitral tribunal now have identical powers like the courts to give interim measures. Arbitral tribunal cannot appoint a court receiver. They have to appoint only a private receiver, but they can do that. Courts have, tribunals have been authorized to do so. Any Section 17 order is deemed to be an order of the court for all purposes and shall be enforceable under the Code of Civil Procedure. And non-compliance of the same is triable under Contempt of Courts Act 71. And no prior approval of the tribunal is required before initiating contempt petition in such a matter. So Section 27 is about taking court assistance and evidence. The arbitrator who can apply for such an assistance is arbitrator may himself apply, or a party with the approval of the arbitrator can apply if any kind of assistance is required from the courts. The competence and according to the rules, on taking evidence is the test for the court to decide whether to grant or reject request under Section 27. So this is the test that courts will also apply. Thus, only when the court does not have power under CPC or Evidence Act to issue the summons, the court can reject an application under 27. They have to basically also see that they have a jurisdiction in the particular matter or not. The arbitrator must give reasons for applying or approving such an application under Section 27, and the court cannot go into the validity of such an approval. If the arbitrator or the tribunal has approved such an application for the parties to go to the courts, court did not have to look into the validity of it. They just have to basically give the kind of assistance that has been sought. These are not the adjudicating proceedings. We must see that when this application goes to the court, they are not adjudicating. The adjudication on aspects such as whether summoning the witness is required or not, and whether relevancy, admissibility, and materiality, etc., is to be determined or not. So this is not an adjudication. The courts does not really have to get into these matters. Now, Section 39 is about the lien on arbitral award and deposits as to costs. Subject to the provisions of subsection 2 and to any provision in the contrary in the arbitration agreement, the arbitral tribunal shall have a lien on the arbitral award for any unpaid costs of the arbitration. So the tribunals are allowed to keep a lien on the awards, basically so that they get paid, and the parties also pay up their dues before the award is given out to the parties. And Section 13 is the challenge procedure, how the arbitrator can be challenged. So now with the new amendments, in fact, the new powers that have been given to the tribunals, the first challenge to the arbitrator will have to be addressed to the tribunal itself. So the tribunal will have to hear on the case of the challenge itself first before they go to the court. Similarly, in case of failure and impossibility to act, Section 14 and 15. And we talk about Section 13 to 15 talks about the independence and impartiality also. There is something called as the fifth schedule, which gives the circumstances which give rise to justifiable doubts as to the independence or impartiality of an arbitrator. There is a seventh schedule which gives the circumstances which renders arbitrator ineligible and impossible for appointment and becomes automatically de jure incapable under Section 14(1)(a). Unlike a non-waivable red list under the IBA guidelines, parties can by mutual agreement waive the arbitrators ineligible for circumstances. In the seventh schedule, parties can waive with mutual agreement. Matters of independence and impartiality under the fifth schedule is to be decided by the tribunal, and matters of de jure incapability under the seventh schedule is to be decided by the court only. So I think we've covered most of the critical sections where the courts can come for assistance, where the tribunal and the courts play a major role. With that, I think I've completed the time. Also, I will share my presentation so that you can distribute to the participants who have a look, and maybe we can dwell deeper into all the sections and the commentaries sometime when we have more time. So yeah, Mr. Gomez, I think that brings me to the conclusion of the presentation, and now probably you can, say, I mean, if you want to take a Q&As or talk about something else.
Yeah, if any of the participants have any doubts regarding the area that is covered, we can hear from, you may ask such doubts.
Hi, sir. Myself, Amina. So, actually, I was curious about the maritime arbitration. Could you please elaborate that? Maritime arbitration?
Okay. So, yeah, see, when I also spoke about the specific sector arbitrations, like we talk about construction arbitration, investment arbitration. Similarly, we talk about the maritime arbitration. When we talk about maritime arbitration being very unique from other arbitrations is in the way that it's kind of like three sides of a triangle that we need to learn in order to be an arbitrator. Also, when I was having discussions or interaction with Mr. Gomez, he was also mentioning to me about that many people feel that arbitration is a field of area of practice only for the lawyers and the judges. So that's not entirely correct. But only there is one thing that to be representing parties as a counsel, you need to be a lawyer, or to be presenting a matter in the courts of law, you need to be a qualified lawyer. But to be an arbitrator, like I mentioned to you, it is the party autonomy. The parties can decide who they want to adjudicate as an arbitrator on their dispute. That brings me to the uniqueness of maritime arbitration, because more than 90%, I would say, as per the records of all the arbitral institutions in the world, more than 90 to 95% of arbitrator appointments in the maritime arbitration happens from the industry people, the people who are experienced in the practice of the maritime trade, the people who have been in the shipping sector for a very long time, who understand the nuances of that particular practice area. Because what will happen is, ultimately we are going to arbitration for cost and time efficiencies. So if we choose a person who does not understand the nuances of a maritime arbitration, the standard form agreements, the bills of lading, what are the documents of proof of your consignments, who is a carrier, who is a consigner, what can go wrong on a ship, what are the various kinds of ships, what are the roles. So it is very important that a person who is adjudicating the dispute is a person who is an industry person. So more than 90 to 95% people are appointed who are from the field. In order to understand maritime arbitration, many people also confuse the maritime arbitration with the maritime laws. So that's only one side of it. The understanding and learning of the maritime law, the shipping law, the various conventions, which are also applicable to the shipping trade, the safety of life at sea, the conventions governing the regulations with respect to the payment of the seafarers. So there are a lot of such things, which is only one side of it. Second side is, of course, you need to understand what the New York conventions are, what are the IBA guidelines, what is the Arbitration and Reconciliation Act. And also, in order to be an arbitrator, it is also a good, advisable thing to learn the Contract Act. Ultimately, all of these are the contracts. And the Evidence Act, how the evidences are taken, what is the validity and the material and the weight you need to give to the evidence, and what kind of evidences are there. But not necessarily you have to be a lawyer, or you have to understand those particular coded laws to be an arbitrator. And maritime arbitration, the most importantly, it is also critical that you understand the kind of disputes that may arise. So there is a distinction that is made in the kind of disputes that may arise in terms of a dry shipping disputes and a wet shipping disputes. Fundamentally speaking, dry shipping disputes which may arise when the ship is alongside, and wet shipping disputes are the ones when the ship is on high seas. Also, to understand what is the classification of the various waters. I mean, what are the national waters? What is the EEZ? What is the continental shelf? Where ships can pass through, or what is the jurisdiction of a particular state? If we see India also, the maritime jurisdiction has been given for arbitration, has now been extended to 8 coastal states. So we have 8 high courts which can exercise jurisdiction in cases of in disputes arising out of maritime business. So I think, maritime arbitration, basically, if you learn the 3 sides of it, one is the conventions which are applicable in the shipping industry. Second is the various laws and the New York conventions and the international conventions which are applicable, and the practice of the trade itself. I think you can become a maritime arbitrator. And the uniqueness is basically understanding the nuances of the maritime trade practice itself. So I think in short, that should tell you about what maritime arbitration is all about, and in case people who are wanting to sit as arbitrators in maritime disputes would like to learn and empower themselves, or basically uh, to gain that capacity to act as an arbitrator.
Okay, sir. Thank you. Thank you so much.
If you do not have any more questions, then we will.
I have a
Yeah.
question. Okay. So in section 80, section 8, I think you were saying that if prima facie there is an arbitration agreement, the person can go to the court to take the matters for arbitration, and that should happen before the said date, for the date of first statement. That was what was said in that section 8. So I didn't understand what is meant by that, before the date of first statement.
Yeah. So basically, if parties go to the court for exercising their powers for referring a matter to arbitration, the courts first of all will look at the validity of the arbitration agreement, and also that the parties who have come to their basically what they have to do is they have to submit a statement of the case, the preliminary the statement which they make about the facts of the matter in that. Before they have done that submission, they basically have to approach the court. But once they have made that submission, then they can't come to the court seeking a matter to be referred to arbitration. But they basically gone into the suit. So basically, they're comparing suit versus arbitration. The parties which have gone to the court and supplied their statement of case now can't come to the courts and seek courts to refer the matters to arbitration. So if you are coming to the arbitration, the courts, you should not have gone to the court and started a suit there by making your by submitting your preliminary statement of case and the facts of the matter. So that is what basically the clause means. The suit you should not have started a suit in the courts in case you want to go into an arbitration.
Clear, sir. Thank you so much.
Okay. Mr. Gomez, I think you're mute.
Let us assume a situation where a suit is filed in a case where there is already an arbitration agreement between the parties, where it is provided that all disputes shall be referred for arbitration. But one of the parties have chosen to file a suit. Then the other party who is a party to the arbitration agreement can file before making his first statement. For instance, it can be a written statement or any other applications or petitions or anything. He has to first file an application under Section 8, produce the certified copy of the arbitration agreement or the original itself, or file an application asking the other side to produce the original, and request the court to refer the parties to arbitration. And the court will refer the parties to arbitration and the suit will be dismissed. This is primarily with an intention to see that if a person submits to the jurisdiction of the court, he cannot come back again and say that there is an arbitration agreement at some later point of time. It is therefore you have to make your application at the first instance itself if you want a reference to the arbitration under Section 8.
Yes, sir. Thank you. Thank you, sir.
So I think we can conclude the session. Uttara, I think that Uttara is somewhere around. Please take
Yes, I'm here. Like I was waiting for the sessions to get over, sir. The appearing sessions, I was not.
And,
I didn't intend to interfere in between.
yeah. Thank you. We have a very important person here. It is Neeti Sachdeva is here. Probably she will come back come back to us in another session. Hopefully, so not. I think that that will not be long afterwards.
Sure, sir. We'll be waiting for that. We'll be hoping that we'll be having her soon.
Yes, Uttara, you can go.
So we can
Go.
conclude.
Yes,
Okay,
yes.
sir. Thank you, Madhavendra, sir, for your valuable and worth listening session, sir. I hope it was indeed beneficial to all the participants here as well. So we have finally come to end of our sessions today. To deliver the vote of thanks, I invite a second year LLB student, Miss Krishna.
Thank you, Uttara. A very warm evening to everyone. We have reached the end of a very informative session hosted by the Law and Justice Research Foundation of Trivandrum Chapter, collaboration with the Cochin Institute of International Arbitration. And I feel much pleased to be delivering the vote of thanks for the session. A big thanks to Team LJRF on behalf of access this session. Rest of the day, Shri Madhavendra Singh, enlightening us his excellent coverage on the topic of the role of courts in arbitration. Thank you, sir. The session was indeed very useful. A big thanks to Advocate Johnson Gomez, sir, the director of the Cochin Institute of Thank you, sir. A deep sense of appreciation to the strong pillar of our LJRF, Mr. Safi Mohan, sir, for his surplus logistic assistance and guidance. Thank you, sir. I would also like to convey gratitude to our this is my advocate. Thank you.
Krishna, are you there?
Yes, Uttara, I have completed.
I think Krishna has also completed her vote of thanks. So thank you, friends, and I mean I must say great thanks to Mr. Gomez for having put this together. And I see there is a requirement that arbitration is emerging in India in a way that we're all can see. I mean it's like evolving in the ways that the laws and acts are being iterated, and there are a lot of improvements which is coming in. All the stakeholders in this field are talking about arbitration. So we are going through a phase where we are not only learning about arbitration, but we are also coming up with new and innovative ways of conducting arbitration proceedings in India. So these kind of events really, harness the real potential of all the stakeholders. And very great thanks to Mr. Gomez for having put together something like this. And I hope you have benefited from the presentation and look forward to being on this panel once again whenever the time permits. And thank you very much. Thank you everyone, or thank you all the participants for being here. Thank you. Thank you, Mr. Gomez. Thank you all.
Thank you so much, sir. Thank you so much, sir.
Thank you. Next week, we will have a session on hybrid forms of arbitration. And Mr. Cruz Anthony has agreed to speak on the topic of hybrid forms of arbitration. Probably it will be relating to arbitration and mediation, or MEDARB, or ARB-MEDARB. You might have heard about such things. Yes. Thank you very much. Thank you, Madhavendra Singh, for joining us. Thank you, Nidhi. Thank
Thank
you.
you very much.
Thank you. Hope you
It
will
was
be back.
quite interesting.
Yeah, hope you will be back with us very soon.
It'll be my pleasure. It'll be my pleasure. Thank you
Thank you,
very much.
everyone. Thank
Thank
you.
you,
Bye.
Madhavendra, for a very interesting session.
Thanking all the participants as well as the speakers, and I now declare the sessions officially over.